Welcome back to Landlord Pass and 3 p.m. BC. I'm Amanda. You've screened, signed, deposited, insured, onboarded, and inspected. Now comes one of the biggest sources of conflict: when and how you can access your own unit. The law gives you the right to access your property, but it also protects the tenant's right to quiet enjoyment. Get it wrong, and you can trigger a complaint or even lose a claim. Module 12 walks through what the law allows and what actually keeps you out of trouble. Here's the core tension. You own the building, but the tenant has exclusive possession of the unit. That's their legal right. The tenant can complain if you enter too much, or without proper notice, or for weak reasons. Even if each entry is technically legal, a pattern can add up to harassment. So your job is to be clear, structured, and respectful about access. The law requires written notice before entry. In BC, that means at least 24 hours notice, but not more than 30 days. The notice has to include 3 things: the specific date you're entering, the time window, which is 8 a.m. to 9 p.m. unless you both agree on something different, the reason, and it has to be reasonable. You can't just text, "coming tomorrow." Written notice means a proper note, letter, or email where you documented consent to use email. Here's an important detail. If you post the notice on the door or mail it, BC law says the tenant is deemed to have received it 3 days later. So if you post on Monday, the notice is considered received on Thursday. Your 24-hour clock starts then. Plan ahead. Don't wait until the last minute or you'll miss the deadline. Valid reasons to enter include repairs or maintenance, fixing a leak, servicing the furnace, checking smoke alarms, condition inspections. You can do them regularly, but see the frequency guidance. Showings, for potential buyers or future tenants. Weak reasons that tenants push back on include just checking in, I was in the area, I want to see how you're living. If you can't explain the purpose in one sentence, don't enter. About showings. You have the right to show the unit, but you need to do it reasonably. Don't hold a 4-hour open house with strangers. That's unreasonable interference with quiet enjoyment. Use appointment-based showings or tight time slots. Control who's there and why. Document the purpose. Showing to prospective tenants is clear and defensible. How often can you inspect? The law allows monthly, but that doesn't mean you should do it monthly. Every month just to check can start to feel like harassment, even if each notice is technically legal. A practical standard, quarterly, balanced and defensible, semi-annual, a minimum for many landlords, monthly, only if there's a specific reason, like you're monitoring a known leak or following up on a maintenance issue. Document the reason each time. There are a few situations where you can enter without 24-hour notice. First, a true emergency: fire, active leak, gas smell, immediate threat. Second, the tenant gives permission right then. Third, a court or RTB order. Fourth, documented abandonment where you have good reason to believe the unit is empty. Anything else? Use the notice process. Even if it takes longer, it protects you. One more important rule: at the start of a new tenancy, if the tenant asks you to rekey the locks, you have to do it and pay for it. That's the law. The tenant can't come in and find the previous tenant's keys still work. You handle it up front. After that, the tenant can't change the locks without your permission. But if you've been entering illegally, they can actually get a court order to change locks, so stay compliant. Common mistakes to avoid: don't text "coming tomorrow" and expect it to be valid notice. Use written notice, not texts. Don't do monthly inspections just because. Have a reason, document it. Don't do open house style showings. Control access and use tighter time windows. Don't enter for emergencies that aren't emergencies. Use the notice process. Don't think one illegal entry is fine. A pattern is what gets you in trouble. Here's a simple template you can adapt. Notice of entry date, time, reason. Please be home to ensure security of the unit. If you have questions, contact. Print it, sign it, deliver it, and keep a copy. The payoff to following this process: no ambiguity. The tenant knows when you're coming, why, and what to expect. You have proof you gave notice. If something goes wrong, you have a clear record, and you avoid the quiet enjoyment dispute before it starts. In Module 13, we're moving to one of the most important workflows: rent collection. how to set up payments, what to do when rent is late, and when late rent becomes a legal issue. When you're ready, join me in Module 13, Rent Collection for BC Landlords.